4, 3, 2, 1.
Oh yay, oh yay, oh yay. This honorable workers' compensation panel is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Justice Campbell.
Thank you, Mr. Hivner. Welcome everyone to this hearing of the Special Workers' Compensation Appeals Panel. We will be hearing one case today. I'm joined on this panel by two of our exceptional senior judges. We have Judge Lee Davies and Judge Kelly Thomas. Thank you both for being here. Mr. Hivner, would you please call our case?
Yes, Your Honor. Albert Randall Worrell versus Obion County School District.
Okay, counsel for appellant, you may begin whenever you are ready.
Thank you, Your Honor. May it please the court. Plessy versus Ferguson was a 7-1 decision that stood as the law for 58 years. According to Lexis, it was cited 145 times by courts during that time, 15 of which were the U.S. Supreme Court. Scott versus Nashville Bridge Company is more than 100 years old, and it's been cited multiple times by this court. But like Plessy, the passage of time and the citation by courts does not make it right. This court should reverse the decision of the Appeals Board and the Court of Workers' Compensation Claims because the 2013 Reform Act violates Article 1, Section 17 of the Tennessee Constitution. It's conscience-shocking at a substantive due process level, and it violates the equal protection clauses of the state and federal constitutions. Article 1 of our state constitution is titled Declaration of Rights, and it touches all three branches in its 36 sections. Section 17, sometimes called the Open Courts Clause, provides that every person shall have a remedy for injury done to his person. The Scott case cites several cases for the proposition that Section 17 was not intended as a limit on the legislative branch. But all three of those, Bledsoe, Dodd, and Pauley, while they apply Section 17 to the courts, none says anything at all about the legislative branch or suggests that Section 17 is limited to the judiciary.
Mr. Holliday, if I could interrupt you for a moment, let's just assume for a moment that that you're right, that Scott should be overruled and that the open courts provision of our Constitution should apply to the legislature. I mean, surely it's not the case that if the open courts provision were to apply, that would prevent the legislature from in any way tinkering with a common law cause of action. So with that assumption that let's say we decide, yeah, we're going to get rid of this. I mean, what framework would even apply to determine whether an action of the legislature violated the open courts provision, and how would you win under the open court, your open courts argument, assuming that were applicable to the legislature?
Yes, Your Honor. So if the open courts applies to the legislature, then yes, they certainly can change the law as long as they provide a reasonable remedy, as Justice Koch notes in his law review article. The question is whether it's a reasonable remedy. And our position is when you look at the history of workers' compensation laws in Tennessee, and you look at the changes that have been made over the years, we've gotten to the point to where the changes in the 2013 Reform Act are no longer a reasonable remedy. And so the court should find that those changes do not provide a reasonable substitute remedy for the exclusive remedy provisions of workers' compensation.
Can you elaborate on that a little bit? You know, in what way is this unreasonable? And I'd like you to explain that argument with respect to each of the amendments that you are challenging. So give us some detail, put a little bit of flesh on that. So why exactly these provisions, these amendments are unreasonable in your view?
Yes, Your Honor. The original, before the Workers' Compensation Act, we have to go back that far to look at why this is unreasonable. And that's because before the Workers' Compensation Act, you were able to sue your employer in tort for negligence. When the Workers' Compensation Act was enacted, that right was taken away, and this was made the exclusive remedy. But the courts have said there were certain provisions. One was the remedial construction, which is at issue in this case. In return for giving up that right to sue your employer, the law was applied in a remedial fashion with all reasonable doubts interpreted in favor of the employee. And so if there was a doubt in this case in the judge's mind as to whether or not Mr. Worrell's condition had been aggravated sufficiently to qualify, the law provided that under a remedial construction, he could find one way we used to say is tie goes to the employee. Second, because it's the exclusive remedy, the employee only had those rights. And under the law, as our brief notes, over the years, those rights have been whittled away by different legislative reforms. And when we get to the biggest change in this case, we have the redefinition of an injury and the burden of proof. Under that, it used to be under the old law, it was undisputed that an employee.
Mr. Holliday, could I interrupt you just for a second? Because I see you've moved on to another topic. You know, you were talking about in your brief the quid pro quo, and I think that's what you were alluding to. One of the real benefits to the employee was, unlike a tort case, even if they were at fault, even if they were negligent, they could still recover as long as they proved they were at work when they got hurt, right? Wasn't that a big thing for the employee to get?
Yes, Your Honor. That was unknown in common law, the right to be able to recover for injuries that otherwise they would not have a right of action for.
Right. I mean, you know, we don't have exactly contributory negligence, but that would wipe them out in a tort case back in time, wouldn't it?
Yes, Your Honor.
Okay, go right ahead.
And that was another benefit that they were given. But over time, those benefits have been stripped away. The court's previous decisions, when it comes to multipliers, while not directly applicable to this case, the court can look at the implication, the use of the 6th edition of the guides, which is well documented in cases that's reduced employer recoveries. The court can look to at first the 2.5 time limitation on recoveries, then the 1.5 time limitation on recoveries, and now simply the impairment rating recoveries. All of these changes have had the undeniable effect of reducing the benefits available to an injured worker.
But Mr. Holliday, I mean, when you talk about this grand bargain that was struck, I mean, it's not as if there was some sort of agreement between employers and employees. I mean, this was the legislature, acting with I'm talking about the original creation of the workers' compensation scheme. I mean, this was the legislature just acting within its authority to create a different sort of remedial system for workers' compensation claims. I mean, there was nothing that obligated the legislature to maintain that system exactly as it was created. So, when you talk about the whittling away, I mean, if you're right that this has been whittled away over the years, why is that a constitutional problem? I mean, you're bringing constitutional claims. So let's kind of bring these arguments back to the legal framework that actually applies in this case, which is that, the analysis that it's really rational basis review. If we talk about your substantive due process claims first, would you agree that the applicable standard is whether it shocks the conscience? Since we're not talking about fundamental rights, we're not talking about suspect classifications. This is just you have to meet a pretty high standard. How do you satisfy that?
Yes, Your Honor. And I agree with Your Honor that is under substantive due process, it is a conscience shocking standard. And when you look at the changes over time that have happened overall in the system, I would take the court to the idea of a rhetorical question of, could the legislature change the law to the point to which when someone was injured, they were required to pay their employer $5 a day for every day they were out of work because of the inconvenience on the employer? If the answer to that is no, which I believe it to be no, they could not do that, then the question is why they could not do that. Because at some point, the quid pro quo becomes not a quid pro pro. There is no equal trade tit for tat there that was thrust upon the workers. And under a substantive due process, my argument is we've gotten to that point with this 2013 Reform Act. The benefits have become such, particularly in Mr. Worrell's case, to put it on this particular case, his claim has been eliminated under the law. He does not have a remedy. His remedy has been taken away from him to receive any future treatment in this case because of the change in the definition of an injury.
Now, is that, let's be careful with, the way we're characterizing this. I mean, is it actually accurate to say that his remedy has been eliminated? And he had a way to pursue his remedy. He did not satisfy the applicable statutory requirements to recover. I mean, that's what happened. It's not that his remedy was taken away. It's that, and the state and the employer here cite to cases in their brief where other individuals have been able to recover that have obtained remedies under the existing scheme. So it's not that the remedy was eliminated. It's just that in some ways, the requirements for obtaining the remedy were changed.
Well, Judge, the remedy for him was eliminated. I disagree with that. We cite in our reply brief each of those cases and why those cases are different from this case. But the idea of a pre-existing asymptomatic degenerative condition, Dr. Pierce testified there is no medically accepted way to determine when that becomes more than 50% the cause of the need for treatment.
In this case, I mean, he didn't testify that for all asymptomatic degenerative conditions of any sort, that would be the case. I mean, he was talking about this case. Isn't that right?
I believe he was talking generally, Your Honor, and if there were a way I could get multiple cases that aren't in the record before the court, maybe you need to look at doing that. But that's been my experience with talking with doctors, is that all of the doctors I've talked to, but I will stick to the record in this case. I believe his testimony was generally that there is no medically accepted way to determine when a pre-existing asymptomatic degenerative condition, particularly Mr. Worrell's shoulder, becomes more than 50% the cause of the need for treatment.
But again, wasn't that just his particular shoulder? Didn't the doctor say that if this situation's condition had been more extreme, it would have been possible for him to say whether or not it was under 50% or over 50%, didn't he?
Your Honor, as best I recall, he had some testimony of perhaps about a knee and the difference in a knee, but I didn't recall that about a shoulder. I'd rely on the record on that. And for those reasons, we would ask that this court reverse the decision and remand this case for a constitutional consideration under our constitutional definition.
Thank you, Mr. Holliday. And we'll hear next from counsel for the appellee.
Thank you, Your Honor. May it please the court, Mara Cunningham, on behalf of the state of Tennessee, intervener defending the constitutionality of the 2013 Workers' Compensation Reform Act. As we've discussed, this is a facial constitutional challenge, which requires appellant to prove that no set of circumstances exist under which the statute, as it is written, is valid. Any as-applied challenge would fail. First and foremost, that was not raised in the administrative courts, which would have had jurisdiction to hear it, and there is no showing of intentional discrimination. This court should hold constitutional Tennessee Code Annotated Sections 102.12 and 116 as they were amended in the 2013 Reform Act, because the elimination of remedial construction in Section 116 and the definition and the change of definition of injury in Section 102.12 does not violate substantive due process. The change in the definition of injury does not violate equal protection. And finally, the elimination of remedial construction and the change in the definition of injury does not violate the Open Courts Clause. Starting with substantive due process, when considering substantive due process claims, the court must consider whether this is a fundamental constitutional guarantee or whether the governmental action is conscious shocking. As we've discussed, the workers' compensation benefits are not fundamentally guaranteed by the Constitution, so the question becomes whether they are conscious shocking. An action is conscious shocking if it is discriminatory and if it does not relate to a reasonably, or if it does not reasonably relate to a proper legislative objective. Here,
Pam, I'm sorry to interrupt you. I was
Yes.
just wondering, I think this is probably where you were going next anyway, but if you could just with respect to each provision that is being challenged here, be precise about articulating what the rational basis is, or there could be multiple rational bases for each of those provisions. And not only what the rational basis is, but how that rational basis is reasonably furthered, because it really requires both. You have to have a legitimate government purpose or a rational basis, and the provision at question has to be reasonably related. It has to reasonably further those purposes. So if you could just articulate both of those things for each of the provisions that are being challenged.
yes, you're right. That is exactly where I was going with this. So
Well, sorry to
this enactment was
thought.
actually created after a year-long study to see what changes would create a more efficient system that is fair to employers and employees. The legislative objectives were to ensure predictability and fairness and to reduce premium rates. All of these objectives have been held as legitimate legislative objectives. As to the elimination of remedial construction, it restores the objective neutrality to the law by requiring fairness, and impartiality in accordance with statutory construction, favoring neither employee nor employer. This is not discriminatory as it is neutral, and as to it reasonably relating to legislative purpose, it reasonably relates because it ensures fairness to employers and employees, and it creates more uniformity in the law to read in favor of statutory construction.
Ms. Cunningham, could the legislature have kind of flipped the construction requirement and said, you know what, now we're going to require that the law be construed in favor of the employer? So, not neutral, but we're actually going to flip it in the other direction. Would that have been permissible?
I mean, I don't know about that. I feel like that may have been. I feel like that wouldn't have really related to the objective of ensuring fairness to both employers and employees. And this objective neutrality is what is ensuring that. So I don't know if doing that would have met the objective. However, the neutrality does meet that legislative purpose of ensuring fairness to both parties. As to the change in the definition of injury, there is no discrimination here. All injuries are treated the same under this change. Prior to this Reform Act, the definition of injury was very bare boned. The Reform Act added aggravation of injury and established the burden of proof to show how an injury can be compensable. So this goes to this elaboration of the statute really goes to the uniformity and predictability in the law, because these amendments are putting in to statute to be consistent with what is being practiced and what the common law has showed. Preponderance of the evidence has always been the burden of proof per common law, and the aggravation of pre-existing conditions need for treatment has always been required to be shown by a preponderance of the evidence that the need for treatment arose primarily out of the scope of employment. The fundamental purpose, as we've discussed, is really that in exchange for the ability to sue under tort, employees now have the ability to be compensated for work-related injuries irrespective of fault. So that is what the grand bargain, I believe, primarily consists of. Contrary to appellant's assertion, there's actually less of a burden and more predictability in the workers' compensation law than in a tort of negligence suits. Both require a preponderance of the evidence, whereas workers' compensation, this just needs to show that employment primarily caused the need for treatment, whereas negligence requires fault. So this is not conscious shocking, as injuries, new injuries, and aggravation of pre-existing conditions are all treated the same under the law, And it now provides more guidance and has more readily available remedies, as is consistent with the grand bargain and the legislative objectives. Moving on to equal protection. Similarly situated individuals are required to be treated the same, and if there is a distinction made, the classification must be reasonably related to a legitimate legislative purpose. As we've discussed, all employees, whether they have new injuries or aggravating pre-existing condition injuries, all the need for treatment is required to show that the need for treatment arose primarily out of the scope of employment. And that must be shown that with a preponderance of the evidence that employment contributed at least 50% or more to the need for treatment of the injury. This is the same for new injuries and those with pre-existing conditions. So there's no distinction made. Appellant claims that there is a distinction due to his belief that the change in the definition creates an impossible burden to overcome for those with aggravations of pre-existing conditions. This is not true, as we cite in our case on State's Brief, page 22. Similarly situated individuals have been awarded unemployment benefits or compensation, workers' compensation benefits, with aggravation of pre-existing conditions. His assertion that his individual case is impossible to meet would be more applied as an as-applied challenge, not a facial challenge. And as we've shown, many individuals have been able to win under this since the Reform Act. So since there's no distinction made, we don't need to show that there's a rational basis, but as we just discussed, these changes are reasonably related to the legislative objectives. And finally, as to the open courts clause, this is not applicable. As Scott decided, it is a restraint on the judiciary, not the legislature. And even for argument's sake, as you asked about, if we were to apply it to the legislative, as we just discussed, there is clearly remedy here. So an open courts clause would fail, even if it weren't a restraint on just the judiciary. If there's no questions, the state would ask that the court uphold the constitutionality of the 2013 Workers' Compensation Reform Act amendments to Tennessee Code Annotated Sections 102.12 and 116. Thank you.
Thank you, Ms. Cunningham. And if counsel for the employer, you can go whenever you're ready. Thank you.
May it please the court. My name is Michael Haney. I represent Obion County School System. Just in response to Mr. Holliday's comment about Mr. Worrell's having his entire claim eliminated, that's not necessarily what occurred in this case. He had a compensable claim. He received benefits pursuant to the Tennessee Workers' Compensation Law, which included a shoulder surgery. He received an award of permanent disability benefits, and pursuant to the Court of Workers' Compensation Claims final order, in this case, he retains future medical benefits for the compensable aspect of his shoulder injury. The only thing that he was denied was the shoulder replacement surgery, which was the subject of the original appeal or the compensation hearing, and then the subsequent appeal to the appeals board.
Mr. Haney, if I could ask you a question then on those facts. I think you're right, but I think what you may have left out, it was a compensable claim. And as a result of that, he had to have a major surgery, correct? The first.
As Dr. Pierce described, right. It was a major shoulder surgery.
And then he goes along, and I guess a year later, maybe he gets hurt again, which requires him to go back to Dr. Pierce. Isn't that right?
He did go back to Dr. Pierce.
And what Dr. Pierce was saying, I think, in his deposition was, anytime you have a major surgery like that, is always going to come, even if you have these pre-existing conditions, which apparently he did have, that were asymptomatic, but he was getting along fine until he had the first initial injury. It's always a very strong likelihood that that surgery is going to aggravate that pre-existing condition. He did say that, didn't he, Dr. Pierce?
He acknowledged that, yes.
And then what he went on to say is the problem I have is it's impossible in this kind of case with this shoulder injury where you've had a compensable injury that required surgery for me then to come back in and put some kind of percentage on it to meet that standard. Isn't that what he said?
He could not identify a percentage.
Right. He said it was impossible.
In his view. I will say in response that I frequently in my practice send causation letters to doctors. And the doctors are able to say one way or another whether or not the injury is more than 50% the cause of the need for treatment. That is the standard in an original claim as well. Whether or not an injury arises out of an employment, the employee technically has the burden of proving that. Yeah. So in this particular case, Mr. Worrell went to court with a doctor who could not attribute more than 50%. I think he did acknowledge that there would be certain fact patterns or certain scenarios where he could say for certain within a reasonable degree of medical certainty, which under the statute now requires the doctor not to speculate and that the doctor must consider all causes.
I think the example he gave was, I've got a knee injury and it's bone on bone, and then there's a injury to the meniscus. In that case, I could always say, hey, there's no way that is more than 50% work related. That in that the example he gave.
Yes, he did give an example of it. And there were some other slight examples he gave regarding a shoulder, if this, if that. But, in this particular case, under these particular facts, he could not say it was more than 50%. And because of that, Mr. Worrell is not entitled to the benefits that he's asking for. But along, from a constitutional challenge standpoint, which is his objective in this case right now, this does not eliminate an entire class of people. It eliminates perhaps certain benefits to certain people where the medical proof doesn't support their claim. There's nothing unique about that. That's been the case under the workers' compensation law since it was enacted. There are going to be cases where the doctor cannot say whether or not the injury is work-related. This just happens to be one of those cases where the doctor said part of it was work-related, part of it was not. And for those reasons, we're requesting that the court affirm the appeals board decision and let the judgment stand. Thank you.
Yes, sir.
Thank you. Mr. Holliday, I believe you have some time, 3 minutes for rebuttal. You may proceed.
Thank you, Your Honor. This is not a procedural change like the MIR process that the court dealt with in Mansell. This is the change of the definition necessarily eliminates a category of people with pre-existing asymptomatic degenerative conditions. Judge Thomas was asking earlier about Dr. Pierce's testimony. I would point to pages 22 to 24 of Dr. Pierce's testimony. The import of his testimony is that he's talking about in general and not specifically Mr. Worrell's case. You can have two workers with the exact same injury in the exact same way with the exact same employer. The difference is one is 18 and one is 56. Under the law, the 18-year-old doesn't have the pre-existing asymptomatic degenerative condition. Their claim is compensable and they have lifetime future medical benefits. Mr. Worrell is excluded from receiving lifetime future medical, which is one of the most valuable benefits under this law.
Mr. Holliday, let me just interrupt you to ask about the difference between what you're required to prove for purposes of obtaining relief under the workers' compensation law and what you would be required to prove if this were just a tort claim. I mean, you still have to prove causation, even if you were under the old, tort regime before the workers' compensation scheme was created. So how is this really more burdensome or giving you a higher burden under the workers' compensation scheme?
Yes, Your Honor. In short, if Your Honor would look at the pattern jury instructions on an aggravation of an injury and what the jury is instructed on aggravation, the jury can look at someone and say, you've got the eggshell plaintiff, and what normally wouldn't have been something, the injury more likely than not caused the aggravation of that injury. Regardless, they don't have to look at a percentage or more than 50%. And the
Well, but
jury
it's
can
more
find-
likely than not, so that, I mean, that is 50, that is a percentage, right?
But it's not it's more likely than not that it aggravated it, not more likely than not it aggravated it considering all causes. And if they can't parse that out, then the tortfeasor buys the entire claim. And that's not the same necessarily in workers' compensation. It is a large change in what the burden of proof that the employee has to over a tort system. Because while both of them use more likely than not, the Workers' Compensation Act adds the definition of primarily out of, that it has to be more than 50% considering all causes. And the aggravation standard under tort law simply doesn't say that. For those reasons, we ask that this court respectfully reverse the decision and remand this case. Thank you.
Thank you, counsel. Thank you for your arguments today. And with that, court is adjourned.